I first introduce myself. I am Dinesh, Research Associate here at National University Delhi and Research Assistant Professor M.P. Singh. Professor Kumari would be chairing this session. We have 4 speakers in this session who would be introduced by Professor Kumari. Thank you.
Good morning. Everybody here? I'm very happy to be here at the invitation of Prabhash, and I feel very honored to be chairing this first session, which is in the whole roundtable has been organized to honor what Professor M.P. Singh has been doing all his life, organizing discussions. And I thought it was just the best tribute all of us who have learned a lot from him could have paid in the manner that he really cherished, whether he was at Prof faculty, whether he was at NUJS, now he is at NLU. Everywhere he is known to ensure that everybody gets to discussion. And I'm very happy to be chairing this session. And I think that chairing is an occasion for compulsory learning. It's called compulsory education programs. And naturally, because if I was a speaker, if I was asked to speak, then I would have known the subject and I would have been asked to speak. I've been asked to chair, so which means that I have to make sure that my 4 panelists today remain to the time, 15 minutes. And I think I'll reserve my questions after I've learned, because once I get education, then I'll have questions. But as a preliminary, I have this question on the we the people of India. Now, who are these we the people? And I'm glad that Justice Sikri brought out this aspect of marginalized sections. Which are the people we're talking about when we're talking about market economy? Whether we the people are, and when we also talk about market economy, are we talking about private spheres being affected by the the market economy, or are we only talking about the public sector? Whether we the people in the public sphere are the ones we're talking about, or are we going to talk about also we the people who live in homes in the private sphere? If we were to go by Justice Garyendrakar's understanding of constitutional scheme, we the people, the women in India who are living in their homes are not entitled to equality, because personal laws are constitutional despite the fundamental right to equality. So somewhere I certainly would want to learn about how we the people who are living within the private spheres are being affected in the private economy, whether it is how does the environment affect we the people living in the homes whose primary sphere is homes, and in the private sphere, how are we getting affected? So I'm certainly looking forward to this session and being educated on various aspects of it. The first speaker listed is Dr. Nupur Chowdhury. She is Assistant Professor from JNU. Nupur Chowdhury is Assistant Professor at the Center for the Study of Law and Governance at JNU. Her current research work includes a qualitative study of urban environmental activism in India, evolving jurisprudence on environmental risk regulation in India, and the design regulatory institutions, environment and public health in a federal polity. She is a member of the IUCN Commission on Environmental Law since 2010, and she also has a blog which I think can be found at, if you were to write Indian Enviro Legal, they should be able to find this. No, I'm just saying, no, if it was search, because I did not read the whole citation, but if they do a search of Indian Enviro Legal, I think you will get her blog and you can follow her on her other writings there as well. I'll introduce the names of the other speakers and introduce more details about, okay, the names are already here, so I'll introduce them as and when they speak. And 15 minutes is the time limit that we're looking at, so that we can have discussion at the end of it.
Yes, I have a PowerPoint.
Somebody can organize that for her?
PowerPoint.
Do you have a pen drive?
Yeah, I have some.
Yeah. You have to move the computer to your podium, and you can do that.
Thank you so much, Professor Kumari, for your introduction. And thanks, Prabhash, for having me here. I'm delighted to be here. This is a rare opportunity that we get to publicly thank our teachers. So I'm very happy to be here and just talk a little bit about one aspect of my research. So my presentation today is it's about the environmental jurisprudence of the Supreme Court, and I'll be looking at 3 cases specifically in terms of highlighting that jurisprudence. So I begin with the hypothesis. What is the hypothesis that I'm trying to defend today? It's that the courts, the apex courts, obsessive pursuit of the writ remedy, and this has been largely to the exception of other kind of remedies that could have been pursued by the court to deal with environmental harm, has limited the ground impact of environmental jurisprudence in India. So this is what I'm trying to argue and prove to an extent to your satisfaction. And what is the methodology that I have pursued this hypothesis with? For the hypothesis explored through 3 landmark cases of the Supreme Court, quite old cases. The Oleum gas leak case, which came up right after the Bhopal gas leak case. The Narmada Bachao Andolan case, so post 1990, we see the imprint of a post-liberalized India. How is the court reacting to that? And the Godavarman case, which is going to complete a decade. It's a continuing mandate. It's going to complete a decade since when the Supreme Court has been hearing the case and passing up orders on that case. Okay, so there are these 3 cases that I'm going to be talking about. Now I know there is a limitation on time, so I'll try and limit. Maybe I'll skip some of the slides, but I'll give you the basic line of my argumentation. What is the argument that I'm making? So there are the 2 primary characteristics that have actually environmental jurisprudence in India. What are the 2 primary characteristics? That the Supreme Court has dominated that jurisprudence. Until unless we had very recently we had the NGT, which is coming into its own. But prior to that, Supreme Court jurisprudence has really dominated environmental jurisprudence. And essentially the jurisprudence, as all of you know, is actually embedded within the Article 21 interpretation of right to life. What is important for us to know is that whenever we talk about the history of environmental jurisprudence, we make these kind of claims. So we say that these are the 2 characteristics and then go on with our analysis. But it's important for us to appreciate and realize that these 2 specific characteristics of the environmental story or the environmental jurisprudence is because of a choice made by a specific institution. And that choice has been made by the Supreme Court. It has made the choice that it's going to actually allow for public interest litigation or social action litigation on environmental violations. And secondly, that it's going to use Article 21 right to life to actually ensure or secure a range of public goods. And that includes clean air, clean water, and so on and so forth, right? And the choice of this remedy basically means that all action on environmental harm is focused on one entity, and that is the state, right? You don't take into consideration other entities like private entities, which are actually probably massive violators of environmental obligations. Right? So, to an extent, this choice has led to a certain kind of trajectory, and that is what I'm trying to question today for you. And what is the result of that choice? The result has been that largely the jurisprudence has been in terms of declarative judicial statements, and it has limited substantive impact on ground. Victims, compensation for victims, exemplary damages for deterrence, what we see in environmental jurisprudence in other countries have not really happened in the case of India. We have very good judgments, but very less impact of those judgments, right? So it is a very academically interesting subject to study, but it's also a very frustrating subject when you discuss it with an activist, because there is very, very limited impact of the jurisprudence on the ground. And what it entails essentially is that it has resulted in a whole chain of elites who actually espouse environmental causes But on the ground, the people who are really affected, the marginalized section of the people, there is very less awareness of their environmental rights, the violations that are there against those environmental rights, and what law could do to provide them recourse. So I argue that the jurisprudence actually has failed to develop an engaged and environmental citizen in India. So that's the basic line of argumentation that I will be following in this presentation. And academically, this has been commented on quite widely, that what is the quality of Article 21 jurisprudence in terms of environmental rights. There has been a lot of principles, but there is a lack of consistency of application, and there is a lack of follow-up, incrementality to build sustained jurisprudence on certain aspects. Certain rights have not happened, right? The court has issued detailed argumentation in its holdings and has left very little guidance on the circumstances, reasons, conditions, application of certain environmental principles. And of course, this court has not been helped by the executive apathy, that is just the story of our everyday lives, on the non-implementation of court's orders. So all of this has been well established academically. And what I would argue is that what if the court, instead of pursuing the writ remedy, had looked at other remedies for environmental harm. When it had got a chance to do that, it could have strengthened tort, like it has done in specific cases. Not really pursued it, but there are some exceptions. Or it could have strengthened the statutory remedies. We have very good legislation on environment, the Water Act, Air Act, Environment Protection Act. But there are certain restrictions on how a citizen can access remedies within these acts. The court could have intervened and could have strengthened those, right? But the court chose not to do that and chose to pursue a certain kind of remedy for whatever reasons, right? I'll just give you an example. For example, in the section 49 of the Air Act, section 43 of the Water Act, essentially creates a bar on when citizens can actually take violators to the court. It is a cognizance of offences by the court can only be taken in when there is a complaint by the State Pollution Control Board and the Central Pollution Control Board. Citizens can take the violators to the court if there is a 60-day notice. Why? No reason. I mean, it's a ridiculous section to have. Then they say that the court, the State Pollution Control Board can actually refuse to actually give the person access to the water sample on which it can actually have the evidence of the violation. By the State Pollution Control Board can refuse access on public interest. So I leave it to your imagination on what is the reason to have these kind of ridiculous sections and why the court does not intervene and actually strengthen and do away with, give a very good interpretation of these sections to do away with this section, essentially nullify these kind of sections. It doesn't make any sense, but the court has not done that. I won't go in depth. I'll just stick to those three cases that I want to make. Those are the case studies that I want to present. So first we come to the Oleum gas leak case. Essentially it's closely coming in the heels of the Bhopal gas leak. And what is on the Supreme Court's mind is atonement. As all of you know, the Supreme Court did not match up to what the expectations in Bhopal gas leak case. So the Oleum gas leak case, the Supreme Court wants to make an example of what should be done when there is massive violation, environmental violation leading to death and so many people. The scale of tragedy is humongous and Supreme Court did not match up to what was expected. Supreme Court wants to do something in Oleum gas leak case. Essentially, what are the facts of the case? Very briefly, there is Shriram Food and Fertilizers, and there is a writ petition against them for closure of that industry because it's hazardous to the community. And during the pendency of that case, there is a gas leak. So the Supreme Court, there was a 3-bench judge that was hearing this case. They refer it to a 5-bench judge, saying that there are a lot of constitutional questions which needs to be settled, and therefore we refer it to the larger bench, right? And there are essentially 3 areas that the court is basically, the constitutional bench is called on to settle. What should be the ambit of the Supreme Court's jurisdiction in Article 32? And can application for compensation be maintained when essentially Article 32 is about a fundamental right violation and a writ remedy for that? Whether Article 21, as was mentioned by the Honourable Judge, what is the definition of the state? in Article 12, and whether you can sue a private entity for a fundamental right violation. So that is the second issue. And then of course, whether you can use the Rowland versus Fletcher strict liability rule, or do you need to make enterprises or legal persons accountable for absolutely accountable, absolute liability rule. So these were three questions. Of course, the court says that it had all the powers under Article 32 to come up with a new remedy to actually make sure that the law has enough force to make sure that a fundamental right violation does not take place. So it says that Article 32 is not a limitation. It actually allows the court to come up with a new remedy. So essentially, it bolsters its powers. But if you come to the definition of the state, this was one of the major issues in the legal issues in this case. The court has fairly detailed discussions on how a private enterprise can be made liable for Article 32 violation if it's actually looking at, if it's an instrumentality of the state. So it uses certain arguments. But then it comes to, very interestingly, it comes to the conclusion that, I will quote what they are saying. They are saying, but we do not propose to decide finally at the present stage whether a private corporation like Shriram would fall into within the scope and ambit of Article 12. Why do they not want to discuss? Because they don't have sufficient time to consider and reflect on this question in depth. We are therefore of the view that this is not a question on which we can make a definite pronouncement at this stage. Whereas they have been precisely called upon to make that definitive statement, actually, pronouncement. But they eschew their responsibility by saying that they don't need to decide it at this time. The court essentially shies away from making a positive statement on this because it's impossible to have a positive finding on whether the constitutional framework or the imagination of the constitution will not possibly allow holding under Article 12 a private corporation liable for fundamental rights violation. So they don't go ahead and make that case. Right? So essentially you have this case where they could actually come up with a very, very clear pronouncement, but they don't make that pronouncement. But they go ahead and make a very nice rule on absolute liability and say that the corporation should be held liable, absolute liable, when it's actually indulging in hazardous activities. And depending on the scale of corporation, how the deep pocket theory, the larger the corporation, the more money the corporation has, the more their liability. So it makes this case, right? But it does not actually apply, it's unable to apply this specific principle in this specific case. So they use this case to make this principle, but they are unable to apply the principle because the facts of the case defy the constitutional framework within which they should have made a statement, but they are unable to do that. Okay, so I won't. Are we okay on time?
Another 5 minutes.
Okay. So I won't come. Let's look at Narmada Bachao. Essentially, again, Narmada Bachao, I'm sure all of you are aware. It's basically challenging the many dams. But basically, this specific case was on the Sardar Sarovar project, and it's challenging the height of the dam and the idea that when the permission for the dam was being given, there is no environmental impact assessment that was done for this case, and that should have been done, right? So essentially, here again, the Article 21 interpretation is, what is interesting is that this case kind of highlights the limitations of Article 21, interpreting it to actually ensure certain kind of environmental public goods. Now we have an Article 21 interpretation which guarantees a range of civil rights, right? And that is essentially a nature of restraint. It restrains state from taking a certain kind of action which would violate the fundamental right of a citizen, of a person. So environmental public goods is not in the nature of civil rights. It actually is a positive entitlement. It requires a certain positive obligation, action on the part of the state to create and deliver such public goods. And the court is always confronted, when you make an Article 21 interpretation, the court is always confronted by this choice. When the executive makes the argument that we also need to deliver development, we also need to deliver employment. Those are also public goods that the state has to deliver. And the court therefore always has to make a choice between one public good versus the other. And the choice will always be, given the context of a country, of our country, a developing country, the choice will, in most cases, go in favor of economic development, employment generation. So environmental violations are then just reduced to actually a denial of one public good against the other. And it shouldn't be the case, but the interpretation of the constitution in a certain manner by the court has made this choice inevitable, right? And of course, at an academic level, this seems like a false trade-off between economic policy imperatives and a set of environmental public goods, but it is assumed significant because at a micro level of specific cases, the court is confronted by this choice, and court then has to kind of give in to what the executive is saying, which means that the state not only needs to look at environmental, clean air, clean water, so on and so forth, but also employment generation, economic development. So the choice is then that, and the state should be allowed to make that choice, what it wants to go with, and the court has to respect that choice, right? So this is a kind of a conundrum that the court of its own making, right? Okay, I'll skip we have some time. So let's talk about the Godavarman case. Essentially, what is the Godavarman case about? It's Supreme Court has basically taken over regulation, forest regulation for the entire country through this Godavarman case. It's a open, continuing mandamus, been open since 1995, and there is a complete ban on felling of trees with a few exceptions. And the court is there is a separate central empowered committee of the court, which is basically tasked with following up, enforcing court orders, and actually also receiving interlocutory applications. So there is a complete bureaucracy that the court has created to look at forest regulation. The bureaucracy which has actually, in fact, made the Ministry of Environment and Forests to a large extent toothless when it comes to forests, right? So I'll give you an example of one order of the court, the National Environmental Regulator. The court has been wanting a National Environmental Regulator for a long time. It has passed many orders, and essentially the court is saying that there is a lack of administrative distance, which is a very old argument between MOEF and the expert bodies. And because there is a lack of administrative distance, essentially it leads to ad hocism. The MOEF very easily overrules expert bodies, and the decisions for giving approvals, any kind of licenses are granted very ad hoc, in a very ad hoc manner, right? So the court is saying we need an independent environmental regulator, and the court has ordered the MOEF to appoint an independent environmental regulator under section 3.3 of the Environmental Protection Act, which is the which was passed post Bhopal, the most important environmental legislation that we have. Now section 3.3 interestingly is the section under which the court wants the MOEF to appoint the environmental regulator. But can section 3.3 allow for an independent environment regulator? No, because section 3.3 of the EPA empowers the central government to delegate authority to a separate body that is subject to the supervision and control of the central government. So essentially it's a contradiction. You can't have an independent regulator because the current regulator has also been appointed under that section, and that section will not allow for independent regulator. You understand? It's not possible to have an independent regulator under section 3.3. But the court obviously cannot go ahead and suggest to the MOEF that you have a separate, you actually have separate legislation on this. The court will breach all institutional, breach all separation of powers, everything, if it actually says that please have a separate regulator, independent regulator, but please have that regulator under some other article of the Constitution that allows for an independent regulator. It is actually restricted by the legislative mandate under the Environmental Protection Act. But the legislative mandate does not allow for an independent regulator. So these kind of contradictions are inherent and actually forces the hand of the court over and over again, right? So I want to conclude by reiterating my argument that the Supreme Court, being a constitutional court, is obsessed with constitutional remedies. There are many other kind of remedies for environmental harms, and that should be explored. And I also think that to a large extent, this narrative is a result of the institutional ambition of the court, which is when it's faced by executive apathy, it wants to be looked at as a doer, which can deliver certain public goods. You know, it was interesting because I was part of a panel in which there was the NGT chairperson, and then there was a Supreme Court judge. And the Supreme Court judge, this was on the panel was about a special issue of of a journal, and there was an environmental issue that it was on environmental law. So essentially, the Supreme Court judge said a very interesting thing. He said that it is the only public institution that can do something about the environment, because we are in a state of nature, which is a Hobbesian state of nature. So there is no government. Life is short, nasty, brutish, and Supreme Court is the only bulwark against complete state of nature and some kind of some kind of a state that can deliver some environmental protection to its citizens. So that is the self-reflection of the Supreme Court, that the executive is completely broken down. It can't deliver any kind of public goods, and Supreme Court should do it, should step into the shoes and do something about this thing. And this reflection of the Supreme Court's role, and it's taken along with the fact that it's a constitutional court, has meant the Supreme Court has been very, very active in exploring constitutional remedies to deliver public goods. But there are certain, as I pointed out through these three cases, there are certain limitations to what the Supreme Court can do, right? I finally end with this argument that what we need is a Supreme Court that is inquisitive and exploratory in its approach and unconstrained by its constitutional role. It should look at actually developing many number of remedies for different kind of environmental harm, and not be constrained by the fact that there is Article 21 jurisprudence and let's go on with that, because it will run into its own, it will run into a contradiction in which it can do little to actually improve the environment of this country. Now, before I close, I just want to add that this is of course a very critical comment of Supreme Court, and this is not to do away with the many good things that have happened because of the jurisprudence, but I think to an extent us academics have a responsibility to move away from not only quoting the good things that have happened, but many more good things that could have come. So that's where I end. Thank you very much for your time.
Thank you, Nupur, for this very interesting critical comment on the Supreme Court. Everybody please write down your questions. We will open discussion only at the end of it. I now call upon Dr. Uday Shankar, who is Assistant Professor at RGSIPL, which is for Rajiv Gandhi School of International Intellectual Property Law at IIT Kharagpur. He has been awarded with a fellowship from prestigious Max Planck Institute of Comparative Public Law and International Law, Heidelberg in the year 2008. He has participated in law teaching and legal research program at Cardiff University, UK. He led a delegation of students for educational summit to George Washington University Law School. He is member of the International Association of Constitutional Law, South Africa. He has completed a project on Ganga River Basin Management Plan, sponsored by Moiz, Government of India. He has been conferred upon the doctoral degree for his thesis on social and economic rights in India by University of Delhi. He has completed LLB and LLM from Campus Law Center and Faculty of Law, University of Delhi, respectively. His areas of interest are constitutional law, human rights, socio-economic rights, and energy law. He has also authored and co-authored a book, Constitutionalizing Intellectual Property.
Thank you, madam. It's a matter of great privilege for me to speak on this topic in presence of my teachers, Professor M.P. and Professor Kumari. Thanks to us for organizing this and bringing all of us here. As rightly said by Dr. Nupur, that we rarely get opportunity to thank our teacher through this kind of academic forum. We generally communicate it personally, so thanks for this. I'll be speaking on socio-economic rights and free market economy because I see close relation between these two. One talks about the ultimate goal, the other talks about the means to achieve that goal. And in this I raise certain questions, and what I'm trying to advocate is at the end of the day, what is important and what has been mandated by the Constitution is we the people should be showered with all the benefits which will make the life dignified. and the course of action which the government decides for ensuring that must commit to the mandate of the Constitution. And that's why I raised few questions and which I tried to address in my presentation. That does right requires resources for its realization? Because that is important, because when you talk about economic policy is all about channelization of resources. Who shall manage that? If it's a planned economy, state shall manage that. If it's a free market economy, it is the market which shall channelize the same. So economic policy designs the allocation of resources. So that's what is the primary role of this policy, that how the resources should be allocated. And if that is the case, then whether economic policy influences realization of rights. Because if right requires resources, then the policy must address that. And socio-economic rights inform economic policy and guide social welfare. Whether the formulation of policy should be in the light of the rights which are guaranteed by the Constitution. Now, when we talk about economic policy, what is this area of operation of economic policy and how it gets connected? Economic decision making always deals with the issues of limited resources and scarcity. So that's how we talk about redistribution of resources. That redistribution of resources is very important in order to ensure that everyone enjoys the benefit. And therefore, the policy, what it does is that it enters into the domain where it addresses the issue of limited resources and allowing everyone to draw the benefit. Now, it has been argued that economic policy should focus only on efficiency and growth, and distribution should be left to actors in political domain. So, efficiency should be the only concern of economic policy. Equity should be the concern of political actors. That's what is an argument. Now, what is the argument of free market economy? Those who advocate for free market economy, they say that income inequality provides an incentive for effort and entrepreneurship, and thereby spurs the efficiency and productivity, and the gains from which will trickle down. So if you allow individuals to grow, if you allow individuals to be entrepreneurs, then the individual will grow and naturally the benefit will trickle down to the bottom. And that's why it has been argued that free market economy is going to do greater benefit. It's going to bring more benefit to the last person who is standing in the queue, which Justice Sikri referred to as marginalized section. So it is said that the economic policy should focus on allocation, but it's the state's function to promote equity and inclusion in the allocation of resources. So it should be inclusive in nature, which was also the point of discussion of Justice Sikri, where it says that inclusive growth should be the agenda. So inclusion in the allocation of resources, where the last person should also be in the agenda of policy formulation in order to ensure that he should not get deprived. So whose role is it? It's generally been said that it's not role of the market, it's the role of the state. And the state shall ensure that there shall be inclusion in the allocation of resources. Now this proposition, the one who advocates for free market economy objects. They say that it amounts to intervention. Let the market govern and let the market address the issue of inclusive growth. So therefore, ownership and control are two important indicators in economy. Who shall own and who shall control? Now when you talk about rights, which I will be discussing, that if ownership lies with the private hand, it satisfies the requirement of free market economy. But when it comes to control of the resources, whether 39B and 39C of the Constitution governs the same. As far as ownership is concerned, let it be there with the market. But when it comes to allocation of resources, let it get guided by 39B and 39C. So, drawing connection between socio-economic rights and resources, it has been said, in fact, one of the reasons for categorization of rights between civil and political rights and socio-economic rights has been need of resources. But then, this reason of divide has already been adequately addressed with this point that both the group of rights require resources for complete realization. whether it's a civil and political rights or it's socio-economic rights. But there is a difference. Difference is, when you talk about need of resources in realization of socio-economic rights, it involves a question of redistribution. Whereas in civil and political rights, it talks about building of the capacity. So in one case, it is the state which takes up the role to build the capacity in case of civil and political rights. In case of socio-economic rights, it's all about available resources to be redistributed in order to bring benefit to all. So justifying the separation of the directive principles and fundamental rights, because most of the socio-economic rights are given in directive principle. So this is what was said by the Planning Commission, where it says that it is the resources which is at the core for this divide. Because new state cannot undertake the responsibility of realization of socio-economic rights, therefore we must have this divide between fundamental rights which are to be immediately implemented, and directive principles should be implemented in a gradual manner. And that's what even the court says in Monroe Abel. Justice Bhagwati says that implementation would depend on the state of economic development. So resources play important role in realization of socio-economic rights. And then it's not that resources only in terms of money which is important for realization of socio-economic rights. There are different kinds of resources which play important role. So we should not be in this impression that it's only money, it's only the monetary resources which is important. It has been established that there are different kinds of resources which are important. So I'm just highlighting that the realization of socio-economic rights solely doesn't depend on monetary resources. There are like monetary resources, natural resources, human resources, information resources, technology resources. In the context of the Rights of Child Convention, it has been said that organizational is also a resource for realization of rights. So directive principle refers to control. However, as I was saying, that ownership could be with the state or private. So ownership is not a concern here. The concern is that who shall control and how the distribution of resources should happen. Now, when you look at the socio-economic rights and economic policy, how it has been in the history. When I look at the Congress election manifesto in the year 1945, prior to independence, what I find is that the manifesto says that the most vital and urgent of India's problem is how to remove the curse of poverty and raise the standard of masses, and for that purpose it is necessary to prevent concentration of wealth. So 1945, Congress said that we must restrain, we must ensure that the policy should prevent concentration of wealth and power in the hands of individuals and groups. Then again, Nehru proposed that newly born state should be socialist, but then he was very clear in his mind that he is not talking about pattern of economy. What he said is that it is, he said that we have let down not theoretical words and formula, but rather content of the thing we desire. So what he said is that towards the end, the goal should be establishment of egalitarian society, not the pattern of economy which is important. So he said that it's not that when we are advocating for socialist state, we are talking about a particular pattern of economy we should take us there. And then Syama Prasad Mukherjee, who in response to the objective resolution, what he said is that he talked about this, that unless we have a socialist economy, whatever we are placing, whatever we are committing to our people, we cannot fulfill it. And then with reference to directive principle, K.D. Shah observed that every citizen should have the right to compel the state to enforce these obligations by whatever means may be found practical and effective. So again, K.D. Shah emphasized on this, that obligations by whatever means. So it is irrelevant that whether it's a socialist pattern of economy or mixed economy or free market economy, what is important is that goal must be achieved. And that's what Dr. Ambedkar says, that we left enough room for people of different ways of thinking with regard to the reaching of the ideals of economic democracy. So that's what was the opinion of Ambedkar, where he says that it's for the government to decide which economic policy it should go for, and that's what is the case even with 25th constitutional amendment. That's what is the case even with 42nd constitutional amendment, which brought in the issue of the insertion of word socialist in the constitution. Then judiciary has been dwelling on the issue of designing of policy relation to the socio-economic rights. Like in case of the Supreme Court said that the framers of the constitution wanted to
wanted a social structure which would avoid the acquisitive economy of private capitalism. So judiciary has been commenting on, the kind of policy or the formulation of policy. Like in Mahesh Chandra, the court has said that our constitution mandates for mixed economy. Then Ranganath Reddy case, the court highlighted on the word distribute, which is used in 39B, and which says that what it fulfills is restructuring of economic order. It embraces the entire material resources of the community, including the resources with individual. That's what is the highlight. And then in Sanjeev Coke again, the court says material resources of the community means all things which are capable of producing wealth for the community. So when you look at these pronouncements, you can very well make out that in terms of resources, the court has been making this point that it's not only the resources available with the state, but also resources available with the individual should be employed for realizing socio-economic rights of individuals. And in 2010, in Reliance Natural Resources Limited, the court says that it must be emphasized that the ongoing process cannot dispense with the role to be played by the state. So ultimately, the state has got a role. The control should be there at the state. Whether resources lies with the individual or with the state is not very significant for realization. Again, in Dalmia Cement, which is 1996, the court says that these principles, they bind government and all agencies, including private agencies. So even private agencies are to honor, they are also supposed to go by the commitment made in directive principle. And then I am linking it with minimum core obligation, which Delhi High Court has said in 2014 in a case where the court has said that for implementation of socio-economic rights, financial constraint will be immaterial. There are certain obligations which are non-negotiable, and in terms of socio-economic rights, there is certain minimum essential which must be honored, regardless of the financial constraint. The state cannot bring in this argument. And why I am highlighting this, that when you are talking about free market economy, we must have this agenda very clear in mind, that there is something which is non-negotiable when you are talking about socio-economic rights, and it must be fulfilled regardless of the fact that whether resources lies with the state or resources lies with the individual. To sum up, what I say is that economic policy should complement human rights instruments instead of viewing it as a competitive values. They are not competing with each other, they are complementing with each other. And human rights focus on worth of every human being, and so should be the case with regard to formulation of economic policy. And therefore, what I say is that nationalization of resources was justifiable in 1980s for furthering the agenda of directive principles. The redistribution of resources to guarantee minimum core of socio-economic right should be justifiable in the present era. And this is what is the last slide on this, that policy should build around prioritization of minimum essential levels. So minimum core should be the agenda, and resources should be redistributed in order to address that. And exploitative economic system would negate the pledge undertaken by the makers of the constitution in the name of we the people. If economic policy fails to create socio-economic conditions in which there will be an egalitarian social order with social and economic justice to all, so that individual liberty become a cherished value. So it is important that when a formulation of economic policy must address this issue, which is at the core of we the people. And I just conclude by reiterating what Professor Singh has said in one of his papers. That he says that the constitution sets the goal of social justice, but it does not set the economic policies by which they alone will be achieved. So this is what the constitution does not talk about any particular economic policy. And he said that national policies cannot be tested in a court of law. So in a way he brings this argument that the court of law is not the right forum to examine policies, and he said that this job is to be undertaken by vigilant parliament. So that's what, in fact, the makers of the constitution also said while formulating Article 37 and 38. It says that it should be the responsibility of the legislature and the executive to formulate the policies in furtherance of the directive principle. That's all. Thanks for listening.
Thank you very much, Uday, for another thought-provoking presentation. And I'm beginning to look forward to the discussion session. I've been provided with all kinds of weapons to make sure that the speakers do not exceed, and I didn't have to use anything. It was just a reminder to that for 5 minutes no more. Now I have the pleasure of inviting Mr. Moiz Tundawala, doctoral candidate from LSE, London. School of Economics and Political Science, and he's a visiting fellow at the NLUD Delhi. He has studied earlier at the School of Oriental and African Studies, London, and the West Bengal National University of Political Sciences, Kolkata. His areas of interest include Indian constitutional and political theory, post-colonial studies, comparative public law, theory of human rights, and Islamic legal theory. You want to speak from here? You want to move? Yeah?
Revered Professor M.P. Singh, other teachers, friends and colleagues, it is a great privilege and a huge responsibility to make a presentation on this auspicious occasion. I hope, sir, I do not end up disappointing you by the end of it. My presentation, I'm a little disoriented because I didn't know about the 15-minute time limit. I had timed myself for 20 minutes or so, but I hope to cover as much as I wanted to within the time allotted to me. My presentation will try to make sense of the constitutional distinction between fundamental rights and elective principles by looking at debates pertaining to the social question in and around the Constituent Assembly. I borrow the expression social question from Hannah Arendt, who makes the provocative claim that the American Revolution was a success because it sought to deal only exclusively with the political domain of freedom, and whereas the French Revolution was a disastrous failure because it tried to find a political solution to the social question of necessity. By necessity, she meant things such as poverty, illiteracy, material destitution. Of course, the Indian anti-colonial movement and the post-colonial moment did not take this assessment seriously. There was a deep engagement with the social question. But nevertheless, we ended up with this divide between fundamental rights, directive principles on the basis of justiciability. And this is what I would try to make sense of. My presentation is divided into two broad parts. For the first part, I would make a case for moving beyond the paradigm of liberal constitutionalism in order to make sense of the way in which social provisions have come to be structured in the Constitution. In part two, I would look for an alternative conceptualization of directive principles in the constitutional imagination of founding framers and characterize them as simultaneously as incomplete norms and as governmental responsibilities. My core argument would be that it is the reason for this distinction, this constitutional distinction, is not because directive principles are superior or inferior vis-a-vis fundamental rights, but because the Constituent Assembly wanted to posit government and parliament as the exclusive embodiment of the will of the people. Now to the first part of my presentation, moving beyond liberal constitutionalism. We often start any discussion on directive principles, fundamental rights by saying that fundamental rights are negative liberties, directive principles are positive liberties, fundamental rights are akin to bourgeois individual rights, whereas directive principles are social and communitarian in orientation. I will not contest, of course these provisions are, part 3 and part 4 do not lend themselves to such easy classification, but I will not develop this argument over here because of lack of time. What I want to emphasize is what this way of classification alludes to, which I want to problematize. What it does is that it seeks, this sort of a distinction is based on presuppositions of liberal constitutionalism, which my argument is that the anti-colonial movement did not really share. What are these presuppositions? most importantly being the distinction between public and private. The public sphere is the sphere of the constitutional political domain, that of polis, whereas the private sphere or the homely sphere of oikos is not supposed to be interfered with constitutionally. So what this leads to is a limited government, things such as separation of powers, checks and balances, conferral of individual liberal rights, and so on. Most prominent thinker in this line being John Locke. My argument is that the anti-colonial movement did not share these presuppositions. I use Partha Chatterjee to make the claim that public and private, this distinction was not at all critical in the anti-colonial movement and in the generation of nationalist thought. What he and I agree with him when he says that what was most critical and determinative was this distinction between the spiritual and the material. Moving ahead, I also refer to Sudipta Kaviraj, who makes the point that contrary to Ferdinand Tönnies, who argues that, you know, if whilst moving from the ancient to the modern, this transition is about moving away from community-based forms of association to more society-based forms of association. Kaviraj's point is that the Indian context and post-colonial modernity, the distinctiveness of post-colonial modernity is not in this, but rather the move away from one form of community to another, form of fuzzy, unenumerated community identities to a form of territorial and enumerated community identities. So it is because of all this, the public-private was not critical. Now, the second point that I would want to make over here within this liberal constitutional paradigm, critique of liberal constitutional paradigm, is that the social question was critical to everyone in the founding generation. Even before that, during the anti-colonial movement, you pick up any constitutional proposal, be it the officially sponsored by the Indian National Congress, in its resolutions in Karachi, Nehru reports, Sapru report, and so on, and other alternative constitutional proposals which may or may not agree with the Congress position, including most prominently Ambedkar, Jayaprakash Narayan, and Roy, Shriman Narayan Agarwal, who wrote the Gandhian constitution. Even though they had divergent opinions about Swaraj, all of them converged on at least this one bit, that social transformation was integral to any sort of project of Swaraj. So now, a third point which I would want to make, and very briefly so because we do not have time, is that, you know, this new recent trend of thinking about fundamental rights, directive principles as exceptions to fundamental rights. That they are but exceptions which nevertheless have to be celebrated, because fundamental rights, if you apply them, you might lead to unfair and unjust consequences. So you need to have exceptions in the form of directive principles. This sort of an argument you find in the works of Mithi Mukherjee as well as Partha Chatterjee. I do not have the time to engage with them thoroughly over here, so I will move ahead. I mean, my point being that we need to move beyond. The problem over here, which with Mithi and Partha, is that they sort of take liberal constitutionalism, nevertheless, as their starting normative point. But my question is, what if we want to move beyond this liberal constitutional paradigm? I mean, Ashish Nandi in a recent interview said that Indian constitution is a trans-ideological document. So now, how do we try to make a move beyond liberal constitutionalism? Which brings me to the second part of my presentation. Now, looking at some of the debates between opponents and proponents of the divide between fundamental rights and directive principles, I would characterize directive principles firstly as incomplete norms, and secondly as governmental responsibilities. This is, of course, within the constitutional imagination of the founding framers. I am not making it all up. Why do I say incomplete norms? I just said that it is not a good idea to start by saying that directive principles are an exception to fundamental rights, but rather they have some normative potential. But nevertheless, they are incomplete insofar as the courts have not been vested with jurisdiction over them, or they were not vested with jurisdiction over them during the founding moment. Of course, proponents like the official Congress view endorsed by Nehru and Ambedkar, I mean Ambedkar's point has always already been quoted by Prabhash sir and Dr. Uday, Shankar as well. So I will not get into all of those things, but just to mention that it is a compulsions of political democracy which they cited in while saying that directive principles should not be made judicially enforceable. Opponents, there were many opponents to this lack or incompleteness of treating directive principles as incomplete norms. I mean, Upendra Bakshi has recently said that it is as though there was a suspension or a constitutional suspension or an emergency with respect to the recognition or implementation of directive principles. I mean, even within this line, the most notable remark came from Ambedkar himself at the end of the deliberations in the Constituent Assembly, where he made the famous speech about India entering into a life of contradictions. He said that if you do not take this bit about social and economic inequality seriously, those who are at its receiving end may blow up the edifice of political democracy that we are trying to create. Now, moving forward to the second characterization of fundamental rights as governmental responsibilities. Over here, it is not to say that these directive principles were inferior to fundamental rights, but rather the emphasis on the institutional supremacy of government and parliament, which was sought to be established. It was said that it is a responsibility and prerogative of the government to enforce them. I mean, two things happened as a response. The judiciary was sought to be completely ousted, and secondarily and more importantly, for my argument, the government and parliament was sought to be made the exclusive embodiment of the will of the people. Now, with respect to the judiciary, there were many conceptual and political reasons as to why they were ousted with respect to having any sort of say in the implementation of directive principles. Most notably, the idea that B.N. Rao mentioned that there is a possibility that socially beneficent legislations may be vetoed by conservative judges. So it is as though the constitution framers thought of them as agents of bourgeois legalism. On the other hand, the parliament, the government in parliament was was posited as representatives of the people. Ambedkar said that legally these directive principles are not enforceable, but they are salient nevertheless in electoral politics. He very interestingly, he likened directive principles, along both Rao as well as Ambedkar, likened them to instruments of instruction. Instruments of instruction, of course, were given under the Government of India Act 1935 by the monarch to the Governor General and other governors in colonies as well as in India. But what had changed for Ambedkar and others was that these sorts of instruments of instruction were being given now not by the imperial monarch, and were replaced by the constituent voice of the people. So it is we the people who, through our representatives in the Constituent Assembly, have given these instruments of instruction to the parliament, to the government in parliament. So it was a sort of a colonial governmentality which he sought the continuation of, but nevertheless by trying to democratize it. And this is a very crucial point. Now, what was its consequence for the people? What about people who would not be in a position to participate in electoral democracy, who would not have sufficient collective strength to be recognized as a force to reckon with in electoral democracy? This point was made by Vishwambar Tripathi when in the Constituent Assembly, when he said that, except for the right to vote, the poor man has got nothing under the Constitution. Similarly, Vishwanath Das, who was a Gandhian, also made the same point that the teeming millions have got nothing in the Constitution with respect to social justice, livelihood and health. There was a reason for positing the government in parliament as this sort of exclusive embodiment of the will of people, which was this, that if you remember, at the time the constitution was being framed, the trauma of partition violence was fresh in everyone's mind, and at the same time what was also happening is that you had these insurrectionary politics, a revolutionary sort of politics which was going on, and you had these peasant and labor uprisings and unrest which needed to be curbed. So what did the government do? They enacted and constitutionally sanctioned preventive detention legislations of the same sort that the anti-colonial movement had sought to challenge. Ambedkar, I mean, we all know, he said that, this Gandhian bloody methods as well as Gandhian methods of satyagraha and non-cooperation and so on are a grammar of anarchy, and they are not suited for politics in an independent free state. So, and of course, this ties up to a lot of these limitations, many other limitations which were absolute and reasonable within the fundamental rights chapter itself, which made Somnath Lahiri lament that it seems to me that, he said that it seems to me that the chapter on fundamental rights in the constitution has been designed from the point of view of a police constable. So to conclude, I would want to say that India's engagement with the social question was by no way unique. In European public law, the social question had been deemed to be important by the beginning of the 20th century. Leon Dubois makes this point that older theories of sovereignty had been trumped by social interdependence as the founding postulate of European public law thought. The idea of social solidarity, positive duties to be imposed upon the state and so on had become prominent. But what makes the Indian case fascinating and interesting is that the engagement with the social question was happening under conditions of post-colonial democracy. I had said earlier that using Kaviraj that Indian modernity was not about moving from community to society, but rather from one form of community to another. In the West, what had happened is that civil society was created much before democracy became salient in politics. So, because of which a lot of these radical revolutionary kinds of people, they moved beyond the purview of constitutional politics. So the social became became prominent through the administrativization of the constitution. Whereas in India, interestingly, civil society was created or was sought to be created through the constitution after adoption of universal adult suffrage. So it was, acceptance of this view. The Indian model is about democratizing a colonial governmentality, and because of which, what happened, twofold things which happened, with which I would want to end, is that on the one hand, the government in parliament wanted to invoke democracy, this idea of we the people, and to claim themselves as embodiments of we the people to generate public power. And on the other hand, they also wanted to curb other institutions, I mean, be it the judiciary, be it extra constitutional revolutionary forces. They wanted to curb these other constituent possibilities, which, if the judiciary and extra constitutional forces had a role to play in constitutional politics, they wanted to curb or limit or restrict and relegate these other alternative radical constituent possibilities to the periphery, to the zone of illegality or illegality. So these simultaneously, these two things were happening, and as a result of which, I submit that the framers of the constitution ended up making this division between fundamental rights and directive principles, and saying that it is only the government in parliament which is responsible for its implementation. Thank you.
Thank you very much, Moiz, for that 15-minute precise presentation. and everybody is keeping so much to the time that I'm feeling that it is only compulsory education today which is happening for me. And certainly it was again a very interesting point that is taken forward on the divide between the two and how do you actually extend the constitution to the private sphere also, because if you were to go away from liberalism, that's where the constitution will have to extend to go. Now I'm very happy and pleased to invite Dr. Timalsena, Executive Director and Principal from National Law College, Nepal, who I had the privilege of meeting recently also in Nepal. He is a renowned legal personality in Nepal. He was the ex-registrar of Supreme Court of Nepal. Currently, he is the Executive Director and Principal of National Law College in Pulchok. Dr. Krishna Timalsena specializes in constitutional law and completed his Ph.D. in Right to Information from Delhi University.
Thank you, Chair. Thank you, Chair. Distinguished panelists, my respected Professor M.P. Singh, Professor Pandey, and other professors. I would also extend my sincere thanks to Professor Ranbir who invited me to be here and to present my experience before this August gathering. And finally, I would like to express my sincere thanks to NLUD Delhi for inviting and making me comfortable arrangement to stay for here for a few days. Thank you very much. Actually, the topic that I has given to this colloquium in honor of Professor M.P. Singh was We the People. And I have learned a lot of things about the word We the People. Who are the people? To my mind, it was a big question. But whenever we talk about social justice, it is the people who are marginalized, who are excluded. If it is the constitution, I think we the people includes everyone. And sometimes even foreigners, whosoever lives in the country. And they can have access to constitutional remedy. In this sense, even the word with the people includes not only the nationals, even the migrants and the tourists may have some sort of voice over the constitutional remedy. That's what, this is a very big question. I am from Nepal, where the constitution is going to be promulgated tomorrow. And 537 CA members have signed just yesterday. And 507 out of 598 said yes to the constitution. Some of the MPs and CA members, say about 57, they are not taking part in the last hour, and about 25 CA members, they have taken part but they opposed the constitution. So in such a critical situation, Nepalese constitution is being made. But there are certain new things that Nepalese constitution adopted, being the youngest one constitution. I will just give some of the examples. Now, the problem of constitution making gave opportunity to make very good constitution. Number one, socio-economic rights, comprehensive rights, even more than that guaranteed by the South African constitution. The Nepalese constitution has now guaranteed socio-economic rights by using the words all, protect, respect, fulfill, and by recognizing. At the same time, the directive principle of the state have been incorporated. Not only directive principles, there are three words: principles, policies, and obligations. There are three words. Some of the principles of governance, policies that need to be adopted by the government, and the obligation of the government to submit its report before President by the government, and the President will put it for the discussion to the Parliament. And also there is a provisions of monitoring committee within the parliamentary system, within the parliament. Whether the directive principles are implemented, whether the government has taken steps to realize these directive principles, there will be comprehensive report to be submitted. It is the obligatory provision under the constitution. These are some of the new things. Another thing, some of the provisions as of today, all as the constitution of our students, we take that fundamental rights are available against the state. Of course, the meaning and definition of state is a little bit broader than we perceive state in another context. But in Nepal, by way of introducing new rights, some of the fundamental rights are available against the individuals as well. Like in India, of course, the right provided to the untouchables, we call Dalit, is available against the person, not to the state as well. And now the right of consumers is available even against the private entity. Because these days the market economy, when we talk, the market is driven by private forces. Even in that situation, some of the rights are available against the private bodies. And the concept now they are trying to introduce is whether the fund is government fund or public fund, whether the function is public function or for public purpose, or whether the action taken serves public interest. These are the three tests to determine the action of the state: public function, public purpose, public interest, at the same time whether there is public funding. These are some of the tests I think that they require even to look at the implementation of other countries' constitutional provisions as well. Similarly, there are certain things we borrowed from the Westminster model of parliamentary system, but with some changes. Now the constitution fixes the limit of ministers, not more than 25 in the federal level. That is one new innovation made by this constitution itself. Again, there is a provision of inclusiveness in every tier of the governance. Even in parliament, one man, one woman must be there, either speaker or vice speaker. Similarly, there is provision, president or vice president, one of them must be women. That sort of inclusion in every tier of governments is included by this constitution. I think this is the one. This sort of provisions is included in the Nepalese constitution, which may be good or bad, but anyway, this is the good beginning to include equally all the say male, female, even marginalized community. This is very good area of discussion under the constitutional law. Also, the constitution that we have now going to promulgate tomorrow talks about three tiers of governance in the federalism: central level, provincial level, and local level. And within the local level, there is a Gram Palika, Nagar Palika, and district assembly. There are three tiers even within the local level. This is constitutionally pronounced three tier of government. Of course, like in India, the center is very powerful in the given situation. If there is nothing is mentioned in the constitution, it is the center who decides the matter. So the residual authority goes to the center. Similarly, in distribution of resources, if the law falls under the domain of center and provinces, in that situation, center may have some policy to determine for the provinces as well. This is something that is developed on the same. The main problem with Nepal is now how to realize these rights, because there is right to housing, adequate facilities of housing, right to employment, right to higher education, right to food, even right of the victims right of the women, right of the Dalits. These are rights where you may require sufficient resources. And previously, even under the interim constitution of Nepal, some of the socio-economic rights were enforceable, but there is no time limit to make law. But now this constitution very clearly says, within 3 years period of time, the parliament must make law to implement the socio-economic rights. It is one of the rights and the mandate given to the government, and they have to pass the law. So it is the mandate not only to the government, it is the mandate to the legislature as well. So they think that the government will not abstain from making this sort of laws in time. It was based on previous experience. Nepalese were very much aware about making constitution by Constituent Assembly since 1950. But the dream now is fulfilled. This is the first time, for the first time in Nepal, the Constituent Assembly is able to produce new content with new visions, and the concept of PPP is also introduced within the direct principles, public-private partnership in economic design. So how would the market will decide? And also they talk about participation of cooperative in the economy. They will give priority. One very strange, or you can say the provisions, the preamble of the constitution talks about creating foundation for socialism. Also the very word is used in the direct principles. The government will take necessary steps for the socialist economy. This provision is there. At the same time, they have included competition-based economy. There are some contradictions. I don't know how they will reconcile in the days to come, but these provisions are included in the new constitutions. Some of the new other provisions, new features, there were a very big issue about religion, whether Nepal should be the Hindu state or the secular state. Finally, Nepal became secular state, but there is no provision to propagate religion. The provision was earlier in the constitution, but now it is dropped. And again, they defined secularism in new way. What do you mean by secularism? And I don't know how the course will develop, but one thing is there, they have understood the meaning of religion in the West and the meaning of dharma in the East. That is not the same thing.